The Fifth Circuit recently ruled that suppressors are not arms and therefore do not trigger 2A protections. And now this is heading in front of the en banc panel, and we just got some new interesting arguments from the DOJ. So let's break down what is happening. Now, really quick before we jump into this video, I just wanted to mention that I know a lot of people who watch this video and this channel in general, you're not necessarily subscribed to the channel. So if you want to support the channel for free, please consider subscribing. That does help the channel to grow. And then also just drop a positive comment down below, because that helps to tell the algorithm that you appreciate this type of 2A content. As I mentioned in the intro, in this video, we're going to be discussing a very significant suppressor challenge that was ruled on by a 3-judge panel in the Fifth Circuit Court of Appeals. The case deals with the constitutionality of the NFA as it applies to suppressors. Now, this is a case we've been talking about for a while, and I think I was one of the first people online who started to talk about this case when it made its way originally to the 3-judge panel, and this case is called U.S. versus Peterson. This case involves an individual who had a gun store at his home, and it was raided by the ATF and a bunch of local law enforcement. And during that raid, the ATF found a single solvent trap that was not registered or serialized. And because of that possession of that one item, Mr. Peterson was charged with violating the NFA and was charged criminally. Mr. Peterson and his attorney at the time tried to get the charge thrown out using a motion to dismiss, and they argued that the NFA is unconstitutional under the Second Amendment as it applies to suppressors. The district court denied that motion, finding that silencers are not bearable arms protected by the Second Amendment. That decision was then reviewed by a 3-judge panel in the Fifth Circuit, and the Fifth Circuit there agreed with the lower court, and they found that suppressors are not arms and therefore do not trigger 2A protections. However, now this case has been filed for Fifth Circuit en banc panel review, and the DOJ just responded to that petition, and they're arguing that the Fifth Circuit should uphold what the lower court said and again find that suppressors are not arms and therefore not protected. Now, this is also even more interesting because you have Pam Bondi and, the whole administration change. However, what you're seeing here in this case is there is a lot of holdover attorneys and offices and agents who are still, pushing anti-gun policies. We haven't seen the full turnover of some of these offices, and that's why you're seeing kind of this holdover Biden administration attorneys arguing that suppressors are not protected by the Second Amendment. And this is all also happening with the backdrop of the Trump executive order going out there, and Pam Bondi is supposed to be putting out a report about all the other actions taken against the Second Amendment. This is probably one of those cases that's also going to be included in that report, and I suspect going forward there's going to be significant policy changes in this case and other ones. But you're seeing holdover arguments, holdover attorneys still arguing against the Second Amendment and arguing that suppressors are not protected. Now, in this case, back in 2022, both federal and state law enforcement officers executed warrants against Mr. Peterson in his home in Louisiana. A federal task force included ATF agents and 50 law enforcement officers who executed that search warrant. The search warrant was based on issues with Mr. Peterson's operation of a gun store out of his home. Specifically, the ATF alleged that there were straw purchases, improper record keeping on 4473 forms, a failure to complete and forward multiple firearms transaction forms, and then there was also issues related to some products that were sold and those later showing up at crime scenes. But out of this entire incident, the one thing that led to this lawsuit was the possession of a single solvent trap that was in his home safe in his own bedroom. In response to this charge, Mr. Peterson and his attorney filed a motion to dismiss the charge based on the Second Amendment. And on review, the court there denied the motion to dismiss, and ultimately he was indicted, but he decided to appeal to the Fifth Circuit and wanted a reversal based on the Second Amendment. On review, the Fifth Circuit 3-judge panel sided once again with the DOJ, finding that Mr. Peterson's motions were properly rejected by the lower court and that the Second Amendment does not impact this issue. In the ruling, the Fifth Circuit stated that whether suppressors constitute arms is an issue of first impression in our circuit, and so far as we can tell, every court to have addressed it has decided the question in the negative. So here, the 3-judge panel in the Fifth Circuit looked at whether or not suppressors are weapons of offense or armors of defense, or used to cast at or strike at another. The Fifth Circuit 3-judge panel incorrectly found that they are not. They stated that Peterson posits that suppressors are an integral part of a firearm and therefore warrant Second Amendment protection. But that is wrong, they stated. A suppressor by itself is not a weapon. Without being attached to a firearm, it would not be of much use for self-defense. And unless a suppressor itself is thrown it cannot cast or strike at another. They state that while a suppressor might prove useful to one casting at or striking at another, that usefulness does not transform a gas dissipator into a bullet caster. Instead, we agree with the 10th Circuit that a suppressor is a firearm accessory, not a weapon. The 5th Circuit 3-judge panel went on to find that suppressors are not necessary accoutrements of a firearm and that they are not required for a firearm to actually be useful or to function. And based on that, they upheld what the district court said. Now, this inherently was a very concerning decision. The fact that the 5th Circuit 3-judge panel here found that suppressors are not a necessary, part of a firearm, that they are not actually a weapon themselves, they're not an arm themselves, they're simply an accessory. That also brought into question about what other accessories a court may deem are also not protected by the Second Amendment. But now this case has been elevated to the 5th Circuit en banc panel. The DOJ has now responded to this petition for a rehearing en banc, and they argue once again that the lower courts got this right and that the suppressor restrictions here are consistent with Supreme Court precedent. One of the concerning things with all this, of course, is that, you have Pam Bondi, who has taken control. She's the AG, has control of the DOJ. But what we're seeing here is some holdover attorneys in some of these cases. This case was not put on hold during this whole transition like a lot of the other cases, like the pistol brace challenges and a lot of the other challenges that are going on. Those were put on hold, but this one is proceeding forward. And because of that, the new policies are not impacting this case as of right now. You still have the old Biden attorneys, some of the holdovers, still arguing for anti-gun policies, arguing that suppressors are not protected. And so I suspect that once we get the report from Pam Bondi, I would hope that this case is also included in that, and then you would see some policy changes. But since that has not happened yet, you're seeing this case proceed forward, and the DOJ is still making anti-gun arguments. Now, in the DOJ's response, they argue that the panel's decision that a suppressor is not an arm because it is not a weapon plainly does not conflict with the Supreme Court's precedent that an arm means a weapon. Rather, it is Peterson's proposed test that would contravene the Supreme Court's Second Amendment jurisprudence. A pillow or a plastic soda bottle taped to the barrel of a firearm can also reduce the noise from the discharge of a bullet. Do these items too become weapons when attached to a gun and therefore gain constitutional protection? So they're saying you can't just simply say that this type of accessory or something attached to a firearm is also an arm, but that's also very interesting, and that's a very strange statement for them to make because the ATF's policy has been that things like bottles or other parts do themselves qualify as suppressors, that they are themselves firearms and also regulated by the NFA. The DOJ goes on to argue in this brief that the case does not present an exceptionally important question. No federal court at any level has found that a suppressor is protected by the Second Amendment. Every court to decide the issue, including 3 appellate courts, have held that a suppressor is not an arm. This is a simple question with a simple, unanimous answer. The panel did not commit an error, let alone an error of exceptional public importance, warranting a rehearing en banc. They state that, in fact, even if the court would be the first to find that a suppressor is protected by the Second Amendment, the NFA's registration requirement would remain in place. The court has already held that the type of background check required by the NFA is presumptively constitutional. So the DOJ states that even if the en banc panel here finds that suppressors are arms and therefore protected by the Second Amendment, they argue that this restriction on this type of conduct or the possession of this arm is still lawful. They argue that the NFA's registration and taxation process is lawful. They argue that it almost operates as an objective shall issue standard, and they say that that's similar to some of the discussion in Bruin by dicta from Justice Kavanaugh, where he talked about shall issue objective standards, and potential permits are lawful or potentially could be lawful. So they are leaning heavily on that type of analysis in Bruin to say that this is an objective standard, it's potentially operating as shall issue, and therefore does not violate the Second Amendment. So now this issue of whether or not suppressors are protected under the Second Amendment and whether or not the NFA violates the Second Amendment is back in front of the 5th Circuit en banc panel. This has become even more interesting with the new administration change, the new ATF director, the AG, and the current executive order from Trump to protect the Second Amendment. and the report and plan that is set to be issued by Pam Bondi. It appears despite, all of that still out there, you still have, a single office that's handling this case in the Fifth Circuit and, some attorneys that are holdovers within the DOJ still arguing against 2A rights. But I suspect, hopefully, and, my hope is that with Pam Bondi and the report coming out and, the full turnover of the administration, a lot of these attorneys potentially would get fired or will be corrected, and they would have to take the new stance that aligns with the Trump administration. So again, a very important case and an unfortunate decision, and currently an unfortunate stance that's been taken by the DOJ, but hopefully that changes very soon. So as things develop, as things change, I will let you guys know. But as always, thank you guys for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.